a well-known individual, the son of one of the most famous actors on the planet, a man who could pick up the phone and reach one of the most recognized people on Earth. And in March 2026, he found himself stuck in Medellin, Colombia, unable to board a flight home to America, not because of any criminal matter, not because of any warrant, but because he presented the wrong passport at the gate. He holds dual citizenship, American and Greek. His U.S. passport was approaching its expiration date, so he figured he would simply use his Greek one. After all, he is a citizen of Greece, a member of the European Union, and Greece has a visa waiver arrangement with the United States. So what could possibly go wrong? The problem is the law. Section 215 of the Immigration and Nationality Act, codified as 8 U.S.C. 1185, states that it is unlawful for any citizen of the United States to depart from or enter the United States unless that person carries a valid United States passport. Not a Greek passport, not a British passport, not an Indian passport. A United States passport. The airline looked at his records, identified his American citizenship, and informed him that he could not board the aircraft with a foreign passport. He needed a valid U.S. passport, and his was about to expire. So there he sat in Colombia, asking his social media followers for help. Now you might be thinking, that is a celebrity problem. That is a wealthy person making a careless error. But Timothy from US Updates Hub wants you to really consider this. If someone with that level of money, connections, and access can get stranded in a foreign country over a passport rule, what do you think happens to an ordinary dual citizen from India, from Pakistan, from Nigeria, from Jamaica, or from the Philippines when they make the same mistake? They do not have a famous parent to call. They do not have a million followers to draw attention to the situation. They are simply stuck. And in 2026, the ways your passport can be taken from you, revoked, denied, or rendered useless have multiplied in ways that very few people are discussing. Today, Timothy is going to walk you through 5 passport traps that are reportedly active right now in 2026. Not proposed, not hypothetical. Active and being enforced. And one of them reportedly went into effect just days ago. If you are a dual citizen, if you are a naturalized citizen, if you hold a green card and you are considering citizenship, this video from US Updates Hub could help prevent you from being locked out of your own country. Let Timothy give you the number that sets the stage. There are an estimated 20 million dual citizens in the United States. That represents roughly 6% of the American population. Some estimates go even higher. Certain analyses suggest over 30 million Americans may qualify for a second citizenship through ancestry or descent alone. And that number reportedly grew again recently. In December 2025, Canada reportedly changed its citizenship law to allow citizenship by descent going back multiple generations. Reports from early 2026 indicate that millions of Americans, especially in northeastern states, may now qualify for Canadian dual citizenship. So the pool of dual citizens is expanding, but at the exact same time, the U.S. government appears to be tightening enforcement from 5 different directions. Let Timothy walk you through each one. The first trap is the boarding denial. This is what caught the celebrity Timothy mentioned at the start. Federal law under 8 U.S.C. 1185 and 22 CFR 53.1 requires every U.S. citizen to use a valid U.S. passport when entering or leaving the United States. There are almost no exceptions. If an airline identifies you as a U.S. citizen and you present a foreign passport, they may deny you boarding. It does not matter if that foreign passport is perfectly valid. It does not matter if that country has a visa waiver agreement with America. The moment your American citizenship is in the system, the only document that works is your American passport. And here's the detail people frequently miss. The U.S. Customs and Border Protection System shares data with airlines through the Advanced Passenger Information System, known as APIS. If you have ever entered the United States on your American passport, your citizenship status is in that system. So even if you attempt to use your British passport or your Indian OCI card or your Canadian passport, the system may flag you. The airline's computer identifies a U.S. citizen trying to board without a U.S. passport, and the boarding pass does not print. Now, a U.S. citizen technically cannot be permanently denied entry to the United States. That is a constitutional protection. But you can absolutely be denied boarding by an airline, which means you never get on the plane. You are stranded wherever you are. And if you somehow do arrive at a U.S. port of entry without your passport, CBP will direct you through secondary inspection. You will be questioned. Your identity will be verified. It could take hours. And while they cannot permanently refuse you entry, the experience is not something you want to go through, especially in the current environment when secondary inspections have become considerably more thorough. The second trap involves child support-related passport revocation. The U.S. State Department reportedly announced that it is now actively revoking the passports of Americans who owe more than $2,500 in child support. This is not new legislation. The authority comes from the Personal Responsibility and Work Opportunity Act of 1996. Under that law, the Secretary of State has the power to revoke or deny a passport to anyone with significant child support arrears. But for almost 3 decades, this power was rarely exercised actively. The only enforcement was passive. If you applied to renew your passport and you had outstanding child support debt, your renewal would be denied. That was essentially the extent of it. Now, the State Department is reportedly taking a proactive approach. They are reportedly coordinating with the Department of Health and Human Services to identify every passport holder who owes more than $2,500. And they are reportedly revoking those passports without waiting for the holder to apply for renewal. The first wave reportedly targeted approximately 2,700 Americans who owe $100,000 or more. But the State Department reportedly made clear that enforcement will expand to everyone above the $2,500 threshold as data collection from all 50 states continues. The total number of affected Americans could potentially reach into the tens of thousands. Let Timothy explain what happens when your passport is revoked. It is not simply a letter in the mail. Your passport number is flagged in the system. If you try to board an international flight, the airline system may reject your document. If you are already overseas when the revocation occurs, your passport becomes immediately invalid. You would need to visit a U.S. embassy or consulate and apply for an emergency travel document just to get home. And you may not be eligible for a new passport until you resolve every dollar of your child support arrears and the relevant state agency confirms your account is clear. Now, why does this matter for dual citizens specifically? Because a dual citizen might think they can simply use their other passport if the U.S. one is revoked. But remember the first trap. You cannot enter the United States on a foreign passport if you are a U.S. citizen. So a dual citizen with a revoked U.S. passport finds themselves in a particularly difficult position. Their U.S. passport does not function. Their foreign passport cannot get them into America. They could be effectively stranded outside the country. An official involved in the announcement reportedly described the U.S. passport as a privilege rather than an automatic right. That word choice is significant and worth noting. The third trap involves passport revocation related to material support designations. Legislation has been introduced that would give the Secretary of State the authority to revoke or deny passports to any U.S. citizen who has knowingly provided material support to a designated foreign terrorist organization. On the surface, that sounds entirely reasonable. Nobody wants individuals engaged in such activities traveling on American passports. But the concern from civil liberties organizations is that the definition of material support in such legislation tends to be extraordinarily broad. It can include donating money, supplying goods or property, providing food or shelter, offering advice or training, performing humanitarian services, helping with recruitment, supplying documents, or providing communication equipment. Organizations like the ACLU have pointed out that such broad language could potentially sweep in journalists, humanitarian aid workers, academics, and even people who made a donation to a charitable organization that later turned out to have connections to a designated group. The concern is also that the appeals process in such legislation may not provide sufficient safeguards. If your passport is revoked, you might have a limited window to request a hearing, but there may be no guarantee of an independent review process, and the power to make the initial determination could rest entirely with the Secretary of State with no judicial review required before revocation takes effect. While such specific legislation may not yet be signed into law, the political momentum behind it is notable. And even without specific new legislation, the State Department already possesses administrative authority to deny or revoke passports in cases involving national security concerns. New legislation would formalize and potentially expand that authority considerably. The fourth trap involves denaturalization, leading to passport cancellation. In May 2026, the Department of Justice reportedly filed denaturalization cases against multiple individuals in one of the largest single-day actions of its kind. These are U.S. citizens whose citizenship is being challenged through civil lawsuits. The individuals reportedly come from multiple countries. According to reports, the DOJ has identified hundreds of naturalized citizens for potential denaturalization proceedings, and reports indicate that the administration directed USCIS field officers to refer a substantially higher number of denaturalization cases per month compared to historical norms. Between 1990 and 2017, the historic average was reportedly just 11 cases per year across the entire country. The current target reportedly represents a dramatic increase. Here's how this connects to passports. If your citizenship is revoked through denaturalization, your U.S. passport is automatically canceled. You would revert to whatever immigration status you held before naturalization, which in most cases would be lawful permanent resident status. But then you could potentially become subject to removal proceedings. And if the government determines that you obtained your green card through misrepresentation as well, you could lose that status too. The potential cascade goes from American citizen with a blue passport to a person with no immigration status who is subject to deportation. And importantly, civil denaturalization under federal law reportedly has no statute of limitations. The government can potentially pursue a case 5 years, 15 years, or 30 years after someone became a citizen. If there were material misrepresentations on a naturalization application, if a criminal record was concealed, if there were issues during the good moral character period, that door may never close. The fifth trap involves legislative proposals to restrict or end dual citizenship. In late 2025, legislation was reportedly introduced in the Senate called the Exclusive Citizenship Act. This bill, if passed, would reportedly end dual citizenship in the United States entirely. Under this proposed legislation, every American would be required to owe sole and exclusive allegiance to the United States. Existing dual citizens would reportedly have 1 year from the date of enactment to renounce all foreign citizenships. If they failed to do so, their U.S. citizenship could reportedly be automatically revoked. Americans who acquire a foreign citizenship after enactment would reportedly lose their U.S. citizenship immediately and automatically. The bill would also reportedly create a federal registry of dual citizens. Now let Timothy give you the legal reality. This bill reportedly has a very low probability of being enacted according to legislative tracking analyses. It reportedly has minimal co-sponsorship and is stalled in committee with no hearings scheduled. And there are substantial constitutional barriers. The Supreme Court ruled in Afro-Yim v. Rusk in 1967 that Congress cannot strip citizenship from an American without their voluntary and intentional consent. The court reaffirmed this principle in Vance v. Terrazas in 1980. Any automatic revocation of citizenship would almost certainly face serious constitutional challenges. But here's why Timothy is still sharing this with you on US Updates Hub. Because the political conversation has shifted. There are reportedly companion bills in the House focused on related themes, and the State Department reportedly reduced the fee for renouncing U.S. citizenship from $2,350 to $450 effective April 2026. That is roughly an 80% reduction. Consider why the government would make it cheaper and easier to give up citizenship at the same moment legislative proposals are being introduced that could force people to choose. Now let Timothy address the biometric surveillance changes that affect everyone crossing U.S. borders. In late December 2025, DHS reportedly implemented a final rule requiring mandatory biometric facial recognition for all non-citizens at every U.S. port of entry, including airports, land borders, and seaports. This is reportedly no longer a pilot program. It is nationwide. When you depart the United States, a camera captures your face and matches it against your entry records. This creates a complete entry and exit record for every non-citizen. U.S. citizens are reportedly exempt from mandatory biometric collection. CBP reportedly states that citizen photos are deleted within 12 hours. But here is the dual citizen complication. If you entered the country on a foreign passport at some point, or if your immigration history shows prior non-citizen status, you may be captured in both systems. Your biometric data could exist in the citizen database and the non-citizen database simultaneously. And when those databases cross-reference each other, discrepancies can trigger secondary inspection, additional questioning, and delays. A 2026 CBP directive also reportedly expanded the scope of electronic device searches at the border. Border searches can now reportedly include information accessible through a device, not just information stored on it. That could potentially mean your cloud accounts, your messaging applications, your email, your banking apps, anything your phone can reach. U.S. citizens reportedly cannot be denied entry for refusing to unlock their devices, but non-citizens can reportedly be denied entry entirely. For a dual citizen, the question becomes which status applies when you are asked to provide access to your device. Let Timothy give you your 5-step protection plan. This is what every dual citizen in the United States should consider doing right now. Step 1. Make sure your U.S. passport is valid with at least 12 months of remaining validity. Not 6 months, 12 months. Because if your passport is approaching expiration and you are overseas, you are one bureaucratic delay away from being stranded. Renew early, renew now, and always carry your U.S. passport when traveling internationally. Even if you plan to enter another country on your foreign passport, you need the U.S. passport to return home. Step 2. Check your child support status immediately. If you owe any amount, find out exactly how much. The threshold for passport revocation is reportedly $2,500. If you are anywhere near that number, work to resolve it before enforcement expands. Once your passport is revoked, you may not be able to travel internationally until the debt is fully cleared. Contact your state child support enforcement agency. Get a current statement and resolve any discrepancies now, not at the airport. Step 3. Review your N-400 naturalization application if you are a naturalized citizen. Pull out a copy and read every answer you provided. Focus on questions about criminal history. Focus on the good moral character questions. Focus on whether you disclosed everything accurately. If there is anything that concerns you, consult with an immigration attorney before it becomes a government case. The pace of denaturalization referrals has reportedly increased dramatically. You do not want to be caught unprepared. Step 4. Maintain a thorough paper trail for everything. Keep copies of your passport, your naturalization certificate, your green card history, your tax returns, your FBAR filings if you have foreign accounts, your child support payment records, and any correspondence with USCIS or the State Department. If any government agency ever questions your status, your documentation is your defense. Without it, you are at a significant disadvantage. Step 5. Understand your constitutional rights. The Supreme Court has been clear on this matter. Under Afroyim versus Rusk, the government cannot strip your citizenship without your voluntary consent. Under Maslanjak versus United States from 2017, even in criminal denaturalization cases, the government must prove that any false statement was material to your naturalization. Under Kungas Verstor, United States from 1988, there is a multi-part test for denaturalization that requires proof of misrepresentation, willfulness, materiality, and procurement. These are high legal standards. The standard of proof in civil denaturalization is clear, convincing, and unequivocal evidence, which is nearly as demanding as the criminal standard of beyond a reasonable doubt. Know your rights. Do not panic, but do not be uninformed either. Let Timothy close with something that captures where things stand in 2026. The same government system that issues passports is also making it possible to lose that passport through more avenues than ever before. Whether through child support enforcement, denaturalization proceedings, material support designations, or boarding denial rules. The passport in your pocket is not just a travel document. In 2026, it may be the single most important legal document you possess. Protect it accordingly. If this information was useful to you, press the like button right now. It costs you nothing, but it helps this video reach other families who need to hear this. If you are not subscribed to US Updates Hub, subscribe now and turn on the notification bell so you never miss an update. Share this video with every dual citizen you know. Share it in your family group chats. Share it on your social media. Because very few people are discussing these developments, and everyone who holds dual citizenship needs to be aware of them. In the next video, Timothy is going to cover what can happen when you sell property abroad and attempt to transfer the money to a U.S. bank. The IRS may know about it before the wire even arrives. There are reporting thresholds that can trigger federal inquiries involving FBER, FATCA, Form 3520, and capital gains considerations that catch almost every immigrant who sells their family home overseas. You do not want to miss that one. This information is presented for educational purposes only. This is not legal, financial, or immigration advice. Every individual situation is unique. Please conduct your own research and consult with qualified professionals regarding your specific circumstances. Timothy will see you in the next video on US Updates Hub. Stay informed, stay protected.